So welcome to this session about the Essential Facilities Doctrine. We are going to address this difficult and always stimulating topic, trying to make a challenge to the most common reactions that followed the publication of the decision of European Court of Justice, the reaction being we are before a change of paradigm. This is very well illustrated by the fact that, according to an author, we should no longer speak about the Essential Facility Doctrine, but in more precise term, although this is clearly provocative, of the Convenient Facility Doctrine, right? The CFD, from EFD to CFD. Is this true? Does that stand? Is an accurate depiction of the scope of the European Court of Justice decision and its implications, or it is not? So we try to see whether we can speak about this decision, stay away from this idea, which is perhaps the most recurring idea amongst the commentators. It has merits, of course, we think it is important to do so. It is interesting to do so for at least two reasons. The first one is of a more general character. It is the Essential Facility Doctrine has almost a symbolic nature, a symbolic character. It has a lot of systematic implications. So it may be dangerous to jump to the conclusion and think and say that this decision marks such an important deviation from the standard interpretation, the standard notion of Essential Facility Doctrine, for all the systematic implication that it has on a general level. The second reason is that this decision comes in the digital era. It speaks about, it falls into the scope, into the area of digital market and digital sector, and it is particularly important for that part of the economy, and also for that part of the legal system. So the interaction between the general notion, the general application of 102 and the antitrust prohibitions in general, and the specific approaches to the digital markets are particularly involved. The case, we thought that we could briefly make a recap of the case, is very simple. We have a platform which is Android Auto that allows apps to be run into your car. And we have an app for electric vehicles that allows to search the charging stations, to have your car navigate, have the app navigate to the selected charging station, then to operate the charging, starting, stopping, and then to pay. So that is the app, and that is provided by Enel, which is the former incumbent of electricity in Italy. Another important feature of the case is that the app sells and works nicely on smartphones, but was prevented to work in a car, into infotainment system of a car, because of the refusal of Google to provide the necessary software facilities to make the app work on the platform. And the quotes that you see on the board also are at the core of the issue that I was talking about, the change in paradigm, it is not important that the platform be indispensable. It is enough that is such as to make that app more attractive to consumers, right? This is why we can speak about a shift to the convenient facility doctrine. The general implication, the general scope of the issue of the doctrine is very much evident out of the way court characterize the interest at stake, right? In terms of high-level value and interest, in terms to the point that it is fundamental individual rights that are thought and said to be at stake, to be at risk. And the quote that you see on the right is from the decision, because the decision takes into account exactly that risk, the risk to erode, to alter, to delete to some extent such a fundamental freedom or right as the freedom of contract and the right to property, and I'm quoting. And the other, in more economic terms, fundamental value at issue is the general working of market in terms of incentive to invest and in the ubiquitous incentive to innovate, right? So at stake, first of all, whenever one speaks about essential facility doctrine, appears those high-level, very impactful issues. This is why it is very often characterized as being something that is at the outer boundary, and that's another quote, of the reach of antitrust rules, and this is why it has this potential systematic relevance, because the way the doctrine that appears perhaps narrow works say a lot about the general reach of antitrust laws. So one of the main critique is this, that it is too wide in this respect, but also there are other critiques in terms of administrability, in terms of judicial competence, and many general theoretic issues like the cost of errors, litigation costs are immediately implied. The second general point to consider is this, and this is another typical, traditional critique. It is a doctrine out of which courts or agencies are transformed into regulators, into regulatory agencies. Because you, at the end of the day, as it is the case with the Italian authority decision, there are injunctions that allows interoperability to be reestablished and allows the app to work on the platform. This is not only relevant for the fact that in the specific circumstances of the case, that is digital markets, the DMA comes into play, but also because a set of other general matters immediately pops up, very, very theoretical, very traditional, for example, rules versus standards, and the connected issue of legal certainty. Is it better to have specific rules that you can anticipate in much a more safe and straightforward manner, as opposed to having to do with standards, as it is in antitrust, ex ante versus ex post, what is the most appropriate tool to use, but also central versus diffuse enforcement. And this is the DMA, where we have the central competence, exclusive competence of the Commission, as opposed to the centralized application of antitrust after 2003. And this is also very well testified by the fact that this is a National Competition Authority case that was brought to the European Court of Justice, but shows one of the mainly debated issues of the parallel application of the DMA and general antitrust laws in terms of the conflict, the tension of competence between national competition authorities and the European Commission. The quote on the right is about some part of the DMA as some application that I took it from an Apple decision, but of course effective interoperability is provided for the specific ex ante kind of approach that one finds in the DMA. This is not the only issue at work, because there is another approach to the point, is the Essential Facility Doctrine working as a sectorial regulation tool as opposed to the general antitrust tool. It is a matter also of the allocation of power amongst institutions, about courts, agencies, and the legislators. So, and this is also related to the issue that we have seen before. It touches upon fundamental rights, so this is for legislators, not for courts and agencies to be dealt with. Having said that, it is very evident that nowadays, especially, and here comes the two decisions that are mentioned in the slide, we are facing out of the field of the Essential Facility Doctrine a very aggressive antitrust, general antitrust enforcement. So without the need of using the Essential Facility Doctrine, both in the US and, as we will see in a second, in the Union. There is, as we probably all know, a parallel application, a parallel case, investigation, court case in the US, and an investigation that just ended before the European Commission about Google AdTech, right? And on one side of the Atlantic, we will know in some weeks or months whether or not there will be a breakup that Google did not incur in the first case, Google search of some months ago. But in the first case, there was, in any case, a very fine and long 6 years set of interoperability obligation being imposed. And in this European case, the same. It is not an EFT case, it is a self-preferencing case, and along with a huge fine again, plus damages from private action, there is a very, at the horizon, because it's not yet established, a very heavy set of remedies. It is, interestingly enough, the Commission has given Google 60 days to come forward with a set of proposals for, say, the behavioral remedies. And in parallel, has said the Commission, I read the quote, has already signaled its preliminary view that only the divestment by Google of part of its services would address the situation of inherent conflict of interest. And that's the other very new and very interesting thing. Speaking about conflict of interest in antitrust, it's not very common. And it is another step towards a very broad way to address vertical foreclosure, right? Perhaps we can have this list, the Essential Facility Doctrine, the self-preferencing kind of abuse, and now the conflict of interest, they all work in a sense whereby you have antitrust without the essential facility being very intrusive, very aggressive in digital, so doing away with all the delicacy and the intricacies and the high-level problems of the Essential Facility Doctrine, and doing very much something close to the sectorial regulator, right? So then, if this is true, perhaps the scope of the decision is not so a revolution, it's not so paradigmatic in a change, but just another adaptation of a very interesting tool which is within a general, quite general framework, right? And the other quote is a quote of Trinco that is perhaps we have a peak of the Essential Facility Doctrine on one side with Google Analytics, and we have a trough with Trinco that marked the end, or at least was welcome as the end of the Essential Facility Doctrine in the US. Then it was not the case. And the quote of another case of Colgate is referring to the fundamental right of the trader to select his counterparty in contract. But then there is a missing point of Colgate in Trinco, that is, this is freely doable by any firm, also by a dominant firm, in the absence of any purpose to create or maintain a monopoly. So I always thought that there is no such a big difference between the Essential Facility Doctrine and any other kind of abuse in terms of limiting the freedom of the dominant company. And then I stop and I leave the word to Francesco Mazzocchi that will help us to have a more precise, detailed idea of the decision and the context in which it falls.
Thank you very much, and want to start by thanking Paolo and their team for having us. And being here is a pleasure and a great opportunity to discuss such an interesting and difficult topic, I would say. We will go through very quickly the facts of the case, and then we'll focus on the indispensability requirement, also in light of the case law of the Court of Justice, and then I will try to draw some conclusions and point to some open points relating to Essential Facility Doctrine after the Android Auto case. So basically the facts of the case were already summarized, but in a nutshell, Enel requested Google to ensure interoperability with an app that offered a set of features for charging electronic motor vehicles. And Google refused on grounds, essentially on security grounds, on the fact that on the need to allocate the resources necessary for the creation of a new template that would have allowed the access, basically the Google Enel app to work with Android Auto. So the Italian Competition Authority concluded that the Google conduct amounted to abuse of dominance, and the refusal was basically not justified. It was brought an appeal, not by Enel, but by Google before TAR, and afterwards before the Consiglio di Stato, which referred the case to the Court of Justice. The Consiglio di Stato in particular considered necessary to obtain guidance on interpretation of Article 102 on refusal of access to infrastructure of an undertaking in a dominant position. So basically the starting point was that Google was dominant in the market where Android Auto operated, And that space, the Android Auto space, was an infrastructure, a digital infrastructure, essentially. And so the assessment on the lawfulness of the refusal should have been assessed in light of the Court of Justice ruling and on the, especially on the Bronner case, which is the landmark case on Essential Facility Doctrine. So in that case, which is very well known, the ACJ ruled that a refusal to grant access to a certain infrastructure developed by a dominant undertaking can be abusive only if certain specific conditions are met. The refusal must be likely to eliminate a competition in a separate market, shall not be objectively justified, and the infrastructure should be indispensable. And this is the key element that we are going to discuss. The case is well known. Basically, a competitor asked to access to a distribution system of a competitor for the delivery of newspaper, and the ACJ, in essence, concluded that the distribution network was not indispensable. There were certain alternatives, and there were no technical, legal, or economic obstacle that made it impossible for other publishers to basically establish their own separate distribution system. So basically, Google argued that the Italian Competition Authority failed to consider whether the Android Auto was indispensable for the Enel app. And here comes the preliminary questions that was posed by the Consiglio di Stato on the interpretation of Article 2 and on the notion of indispensability in the digital arena. The Consiglio di Stato asked to consider if it was possible to basically adopting a more flexible approach and to cover a notion of indispensability of a more convenient use of the product or service offered. There is another question about effects on competition that's probably it's less interesting, and we will stick with only with the first question, which is deals with indispensability requirement. So Bronner, as mentioned, is the landmark case for the Essential Facility Doctrine, at least from the point of view of the European Union. This is how it is considered, but it is in line with the approach that was followed by the Court of Justice in old cases that are McGill, that are actually before Bronner, and IMS Health. So all these judgments basically consider the indispensability a condition that must be satisfied in order for a competitor to try to access the facility of a competitor. In IMS, there is an additional point, which is the fact that both IMS and McGill relating to refusal to grant a license, so by an owner of intellectual property right, there is an additional condition that should be satisfied. That will be the fact that the license, the competitor intended to offer a new product or service. So what is the rationale behind the indispensability requirement? Why essentially the bar is so high for competitors to ask access to a competitor's facility? The rationale was summarized, a possible rationale was summarized by Advocate General in the Deutsche Telekom and Slovak case, and making reference to the Advocate General Jacobs in Bronner. The key point was that the rationale in penalizing a refusal to make available, refusal to access, to allowed access, which essentially amounted to require an undertaking, a dominant undertaking to conclude an agreement, is more detrimental to the freedom to conduct business and freedom of propriety compared to other conducts. This is for the reason These are the reasons why mandatory shall be construed narrowly, and the legal standard is high and possibly higher than other conducts covered by Article 102. So we said already some words about the comparison with US, so I will not say more on that. But the judgment in a nutshell is on the fact that the ACJ clarified in Android Auto that the indispensability condition does not apply where a dominant company has developed infrastructure. In this case, it was a digital platform, of course, with a view to enabling third-party use. So basically, the rationale is that company already assumed the cost of developing the platform for the benefit of third parties, and therefore the obligation to open that device to third party to ensure interoperability does not therefore fundamentally alter its economic model, so there is no impact on incentives, essentially. This is the underlying thought. Bronner stayed apparently alive for other cases, so conditions where the infrastructure is was developed by the dominant undertaking solely for the needs of its own business. And the facility in itself, it's owned by that undertaking. So the underlying thought is that in that case, investments were made, and so in order to protect free riding and incentives by the dominant party, a higher standard should be applied. But so basically, the ACJ concluded that, I don't know how much, concluded that the Bronner condition is not applicable in this case. And so this is only the last step of a longer journey by the Court of Justice in which there was a significant departure from the original Bronner interpretation of the condition, and especially on this indispensability requirement. For example, the ACJ specified that the requirement does not apply when the assets were voluntarily made available to independent players who pay the right to use them. This is a pretty early judgment. It does not apply for other types of conducts like unfair or discriminatory terms and conditions. There are a number of judgments that are arguing this, also Google Shopping, and does not apply to margin squeeze practice. Those are, according to the court, standalone practices, abuse. There is no need to ensure a further layer of protection because the agency or the judge is not interfering with the right of property or the right to choose its own counterparty. It does not apply either in the presence of regulatory obligations, because in this case, the underlying idea is that the balancing test between opposite values has already been done by the regulator. Also does not apply if the infrastructure in question was financed with public funds, because the underlying idea is not, there is no need to protect the investments. And also for more simple reasons in case the infrastructure was destroyed. So there are a number of, let's say, exceptions or to the Bronner original formulation. So we made there's a long distance from long journey from the original Bronner case that significantly reduced the scope of the relevance of this condition. According to Advocate Medina in a recent case, Bronner is still alive for certain specific circumstances where the infrastructure is owned by the undertaking and there is an exclusive right and there is also in the context of a liberation process. This is interesting, but it's a very, very narrow space where the original conditions by the Bronner are alive. So one could argue and ask whether Bronner was originally conceived to set general principle and criteria. According to the Court of Justice, recent judgments of the Court of Justice, no. This is the answer is no. It's very linked to the specific facts of the case. Also, I think Advocate General Jacobs was very cautious to consider that case as a landmark case and the right arena to put forth general principles. I think it's pretty evident in paragraphs 55 and 70 of the conclusions of Bronner case. And but still, we have seen that the early case law was pretty clear, in particular IMS. More in general, one could ask whether these different legal standards for pure refusal to access are needed. According to eminent practitioners, it basically all boils down to effects of incentives and effects on competitions, and so a case-by-case analysis is needed for each single case. As a lawyer, we would hope that there will be some general principle and criteria, if not Bronner, another case that would provide some guidance, because the situation is quite difficult, in my opinion, to detect. There are specific implications on the digital platforms because the conditions seem basically impossible to meet because digital platforms are ontologically opened. And so how could you rely on the Bronner conditions in this case? And this is, I think, it's an interesting feature because traditionally the infrastructure has always been neutral. So an infrastructure could be an information, a port, but possibly it cannot be a platform or an app. This is something that one could consider. And as a very final remark, from this, from the cases from the Court of Justice, it seems that the only and the last bastion in the end of the dominant undertaking is objective justification that could, it stayed from the early case law, and it's something that a dominant undertaking can rely on in order to exclude the abuse in a specific situation. So I will leave the floor to Mr. Parco.
Thank you, Francesco. I think that we clearly see that the leading feature is, I would say, the adaptation of the tool to the specificities of the situation. We also have seen that Bronner doesn't work very well as a paradigm to be used to say we are no longer in the old paradigm because of this new case. But I immediately leave the word to Pierluigi Parco that would address the issue in the perspective of economic analysis.
Okay, thanks. Okay, let me thank the organizers, all the organizers of this, and thank you for the invitation. I'll be very quick. I think that we mostly agree with the things we are saying. I just try to go quickly in a different angle. But let me start from something that some of you might remember, Paolo Uccirosi for sure. Herbert Simon, in 1991, wrote an interesting thought experiment and said, if a Martian would arrive to the Earth and see the economics of the Earth from far, he would see what? He would see big green areas that are the black boxes, the firms, and small red lines that connect them, so the markets. His reason was to explain that firms are much more important and wide than markets, and markets are really thin areas. I'll come to Simon at the end in a second. Okay, let's move quickly through this story. The story is Bronner, as I read it, Microsoft, Deutsche Telekom and TeliaSonera, Enel, and then what is the economic meaning of all this? Well, Bronner is the Essential Facility Doctrine. It's not only Bronner, we know there are other cases, but it's an Essential Facility Doctrine based on the idea that this should be really an exception. Forcing a firm to share his own facility should be something that creates a profound intrusion into freedom of contract and investment incentives, so it should be something very rare. The obligation can be done only in exceptional circumstances. I was explained there are certain conditions that should be there. I don't repeat them. They are all there. Let me underline, was already done, the fourth, the idea of the new product. Why the new product is interesting? Because the new product comes immediately in 2007, a few years after Bronner, with Microsoft. In Microsoft, Bronner is applied, at least my reading, Microsoft is a very difficult case, but my reading of Microsoft is that it is an application of Bronner. That means if you have software interoperability, it's impossible to interoperate with a system of the strength, the dimension, the network externality of Microsoft is impossible without an interoperability opening from Microsoft. This means that you are in phase of a network effect and technological lock-in, without which you need absolutely this system to be opened. So what is the question there? Who was trying to interoperate with Microsoft? Weren't new products, but were new technical developments. So in Microsoft, Bronner was extended to say there is no need really only of a new product. You cannot stop technology. You cannot stop the technical developments. That was, I think, the real message. Duplication was economically and technically simply impossible of the Microsoft system at that time. That was the judgment. So Microsoft is a continuation of Bronner, in my opinion. Then we arrive to the margin squeeze story that has been declined now, but has been a major story for many years. And is the story of a situation in which Deutsche Telekom, for instance, was obliged to regulate to grant competition wholesale access to this local loop, and did the margin squeeze by pricing that were unbearable for the as efficient competitors. Well, what is the question there? Why is not Bronner anymore? It's not Bronner anymore because the indispensability is not an issue. The access was already given, so you were already inside Telecom. You were using his own tools, and so the indispensability requirement was out. So this is not anymore Bronner. By the way, TeliaSonera, that comes immediately after, goes a step further, because in TeliaSonera there was, in Deutsche Telekom there was a regulatory obligation to open the network. In TeliaSonera there was no regulatory obligation, but still you had opened the network. When you open the networks, then you have to respect certain, you cannot do margin squeeze. Okay. Then we arrive to Enel, that is our story today. Well, in Enel, clearly, the design of Android Auto was an internal facility that from the inception was designed for third-party application. So it was open by design. When something is open by design, again, it's the same story. There is no question of indispensability. You are open. So, as was said before, I quote here from the court, provide access to the infrastructure to a third-party undertaking doesn't fundamentally alter the economic model which was applied to the development of the infrastructure. So you are not damaging the economic model. The economic model is already ready to have people inside. Then let's then there are details I don't enter on why, how it should have done, but they were already explained. Let me come to the economic meaning. Is a shifting, I think it's a story that has some consistency, is a shifting of economic theories about access, innovation, and the role of dominant firms. Bronner is the idea, the Schumpeterian idea of the defense of incentive. You don't want that a firm should be given incentives that discourage its investment in infrastructure, is development. So that's why should be truly an exception. Then arrives Microsoft, in which you say, and resonates with modern theories of cumulative innovation, that a refusal by one actor cannot block a chain of complementary technological developments. So you see, are two different theories of dynamic innovation here. You don't want to jeopardize the dynamic investments of firms, but also you don't want firms to not to jeopardize the dynamic innovation, the complementary innovation and this development. It's an equilibrium. And in Microsoft, the decision was that using Bronner, you could shift the equilibrium in that direction. Then you come to Deutsche Telekom and these other things. These are other things. This is a different angle. The access is already decided, and then it's clear that you have to respect certain rules. But however, these margin squeeze stories are interesting because they are, in a sense, preparing to NLX to the platform question. And the platform question is, in a sense, the same thing. Once the platform is open from the start, like in the margin squeeze stories, then you cannot have selective exclusion, the discord competition, and downstream, and the previous consumers of choice. This is the point of NLX in the end. So my point is this a coherent trajectory? Well, you can read it as a coherent trajectory. I leave the question mark because some doubts are there, obviously, as always in the court that writes in a complex way. But anyway, Bronner, compulsory access is an exceptional remedy. Microsoft, refusal of interoperability meet Bronner's condition in digital markets, so it's a next step. Telia Sonera, indispensability irrelevant when access is already given. And this brings us to NLX. When the platform is opened by third parties by design, then refusal of interoperability and discrimination can be abusive without any indispensability or any other specific requirement. Maybe only the justification, the impossibility justification. So, to conclude, the essential facility doctrine of Bronner remains apparently intact as a truly exceptional claim to force access to proprietary assets. And there are situations, however, many, and we are seeing that they are becoming more and more, in which this question of access is not the center of the question. Then the access principle is already solved a priori and is not the core of the case. In these cases, the Article 102 and the DMA, regulation and antitrust, are telling us that a digital platform cannot, once it's open by design, cannot arbitrarily foreclose rivals. So coming back to Simon, if the Martian arrives again and looks at least at Europe, because I'm not sure about the US results, we'll see. He will see still the green areas, black boxes. He will see still the line, but he should see, if we take the court seriously, some translucent areas that are these quasi-markets that are the platforms. The platforms should be translucent. And so the red lines of market relations should be seen through the platforms. That's what the court is asking. Thank you.
Thank you. Thank you very much, Pierluigi. It is very late. Let me just add some concluding note. That is, perhaps the essential facility doctrine can be seen as a flexible tool that may work in parallel with the sectorial regulation, the DMA, so you can have the beauty and the benefit of ex-ante specific detailed rules and the legal certainties coming out of that. And you can also have a sort of background, as the antitrust rules are, background tool that steps in and may adjust the intervention if it is done. And we have seen there are many ways. I also put the question mark because it is necessary to do it, but many ways to see consistency and to see continuity instead of breaks and concerning deviation. So perhaps again, the way to use the essential facility doxing is to use a tool that is very flexible and can adapt as it is being adapted. It was adapted by the courts and the agency along the road. Any question? Perhaps a few minutes. We can still have time for any question from the audience. Apparently not, so we can go on with the social part of the event. Thank you very much.